So today is our sixth and last session of ongoing playlist, which is Law Journal. It carries 10 marks of theory as per IBBI existing syllabus, and with effect from 1st July 2022, it will carry 9 marks of theory. So in today's session, we are going to cover Insolvency and Bankruptcy Code, Companies Act, important sections as per IBBI syllabus, and we will also see salient features of the Companies Rule, Registered Valuer and Valuation Rule 2017. So this is the full syllabus. Point number 1 to 7 we have already covered in session number up to session number 5 till law of evidence, this point, and Surface Act we have also covered in session number 5, and BR Act is also covered. So today we are going to cover about IBC, Companies Act, and Companies Rule. So Insolvency and Bankruptcy Code 2016. So though it is a big act, but from examination perspective we need to have understanding of a few important points which we will cover in today's session. So valuation process as per IBC code is as following. So following are the major steps involved in valuation process under IBC 2016. So first step is issue of RFQ, request for quote. Please note down this terminology. Then issue of appointment letter, engagement letter to valuer. Third step is disclosure, conflict of interest by valuer, if any. Request for information, valuer seeks the information from the concerned parties, lenders or companies. Then fifth step is site visit or inspection by the valuer. For the sixth step is draft valuation report submission by the valuer. And the seventh and last step of the valuation process is submission of final valuation report. Please note down these 7 steps. So what is the process of appointment of registered valuer as per IBC code? So the RP is nothing but resolution professional. Please note down this terminology. Shall within 7 days of his appointment or 47 days from the insolvency committee date, whichever is earlier. Please note down this timeline. Theory question may come out of it. Shall appoint 2 registered valuer to determine fair value and liquidation value. So here 2 types of valuation are required to be submitted by the valuer. One is fair value and liquidation value. Both valuations are required. Of the corporate debtor, any of the following people cannot be appointed as registered valuer. So 1 mark theory question may come out of this first point, second point, and this third point. A relative of RP, resolution professional, a selected party of corporate debtor, an auditor of the corporate debtor at any time during last 5 years preceding the insolvency commencement date, or a partner or director of insolvency professional entity of which the RP is a partner or director. Submission of fair value and liquidation value. The 2 registered value after visiting the asset shall calculate fair value and liquidation value of the assets. The valuer shall follow internationally accepted valuation standard for calculation. Please note down these standards. The valuer and RP shall maintain confidentiality of the 2 valuations. RP may, resolution professional may ask or appoint third valuer if he finds 2 valuation from 2 valuers are significantly different from each other. The average of the 2 closest estimates of a value shall be considered the fair value or liquidation value, as the case may be. After receipt of resolution plan, the RP shall provide the fair value and the liquidation value to every COC. COC is nothing but committee of creditors in electronic form after receiving an undertaking from the members that such member shall maintain confidentiality of fair value or liquidation value and shall not use such value to cause an undue gain or undue loss to itself or any other person. So after taking this undertaking, committee of creditor can be provided access of the valuation report. So RP can provide these valuation report in electronic form to the lenders, but RP should take undertaking into this format from each lender. This undertaking is required to be submitted by each lender. Fair value. It is the estimated realizable value of the asset if they were exchanged in the insolvency commencement date. Please note down this thing, that fair value is being calculated on the date of insolvency commencement date, not as in date of valuation. Otherwise, all other valuations are being done on the date of visit or date of valuation. However, in case of IBC, the valuation fair value is calculated as on date of insolvency commencement date. Very, very, very important question. Normally, it comes in exam. Between a willing buyer and willing seller in an arm's length transaction, after being proper marketing and where parties had acted knowledgeably, prudently, and without compulsion. What is the definition of liquidation value? It is the estimated realizable value of the asset if corporate debtor were to be liquidated on the insolvency commencement date. So these two definitions are very important from IBC code, because here valuation, fair value, liquidation value are calculated as on date of insolvency commencement date, not as on date of present date, date of visit or date of valuation. Valuation for voluntary liquidation. One of the documents required to file a voluntary liquidation, the corporate need to submit valuation report of all assets of the company. So if I am a corporate, I want to apply for a voluntary liquidation of my company, I need to submit a valuation of my all assets. That is called valuation for voluntary liquidation. So there are certain unique challenges which are being faced by valuer under IBC process. So they have limited or no access to the documents. They get limited time to do the valuation. They also get limited or no access to the premises of the property to be valued. Limited or no access to the recent financial statements and books of account might not be possible to the valuers. And then challenges of shutdown unit, factory may be closed, which is required to be valued by the valuer. The limited practical exposure of CIRP, corporate insolvency resolution professional, so lack of experience, expertise, and possible litigations. Valuer may get entangled into litigations also. There is a huge potential, huge scope of litigation against the valuer as well. So there are certain responsibilities of registered valuer as well. The registered valuer may obtain inputs for his valuation report or get a separate valuation report from another valuer. It is allowed as per IBC. Detail of such report, if any, should be disclosed in the final. If at all he has taken any help of any outside valuer, outside person, those details should be explicitly mentioned in the disclosures in the valuation report. However, the liability against the final valuation, irrespective of the nature of input or valuation given by the other registered valuer, shall remain with the first valuer, first mentioned registered valuer. So if I am giving a valuation under IBC, I can take an opinion from you as a valuer. I can mention your details that I took these guidelines or these information from you. But the ultimate responsibility of providing the final valuation shall remain with me only. So other person will not be responsible. So entire responsibility will be with the valuer only. So there are certain model code of conduct for registered valuers under IBC also. The valuer shall not disclaim liability for his expertise or deny his duty of care. The valuer shall not indulge in mandate snatching, very important term from examination perspective, or offering convenience valuations in order to cater to a company or client's need. As an independent valuer, the valuer shall not charge success fee. So this mandate snatching, convenience valuations, the success fee, please note down these terminologies. A valuer shall maintain written supporting document and calculation documents and calculation data based on which he has calculated the valuation. So supporting document calculation he should keep with him. Next is Companies Act. So now we are going to discuss about important salient features of Company Act from IBBI valuation exam perspective. So what is Companies Act? The Companies Act is an act of Parliament of India on Indian company law which regulates incorporation of a company, responsibilities of a company, directors, dissolution of a company. So these are the from IBBI examination perspective, though this law is a big one and even 100 hours is less than for covering the complete law. But from examination perspective, only few things are required to be noted. So one important thing is that we should know various types of companies and their important features. Any 1 mark theory question can come out of this portion. So primarily these are the main types of companies as per the Companies Act: private company, public company, one person company, foreign company, government company, the listed company, dormant company, and nidhi company. So this is a comparative table showing the comparative analysis between the private and public limited company. So please remember these common features, important features, out of which 1 mark theory question can come in IBBI examination. So if we talk about private company, then minimum members, member means shareholders here. So minimum number of members or shareholders in case of private company as per Companies Act is 2. However, for public company, the minimum number is required as 7. So maximum number of members or shareholders in case of private company is 200. However, in case of public company, it can be unlimited. Minimum number of directors in case of private company is 3, and in case of public companies, in case of private companies it is 2, and in case of public company it is 3. And minimum capital in case of private company is 1 lakh rupees, and in case of public company is 5 lakh rupees. And transfer of share is not allowed in case of private company, it is restricted. However, in case of public company, shares can be allotted to the public in general. One person company, it is a new type of company introduced in Companies Act 2013 and has only one person as its member. So it is nothing but a hybrid model of sole proprietorship and the company form of business. So it has been provided with concessional and relaxed requirements under the Act. So previously sole proprietorship firm used to exist, and even today it also exists. So just to formalize that single man arrangement, this one person company concept has been introduced in Companies Act 2013. Foreign company, a company in which incorporates outside India and has a place of business in India, whether by itself or through an agent, physically or through electronic mode, and conducts any business activity in India in any other manner. So next type of company is government company. It is a company in which more than 51% of paid up capital is being held by state government and or central government. Listed company, it is a company listed on stock exchange like NSE, BSE, etc. Dormant company, a company formed under the Companies Act for future project or to hold an asset or intellectual property and has no significant accounting transaction. It is called dormant company. Nidhi company, it is a company incorporated with an objective of cultivating habit of savings among its members, receiving and lending money to its members only for their mutual benefit. So these are a few important sections of Companies Act 2013 which are relevant for valuation of properties, and 1 mark theory question may come out of number of section and scope of each of these sections. So first important section from valuation perspective is section 192 and subsection 2. It talks about restriction on non-cash transactions involving directors. Then second important section from valuation perspective is section 230(1)(2)(3). It talks about power to compromise or make arrangements with creditors and members, compromise, arrangement and amalgamation. Then section 231, power of tribunal to enforce compromise or arrangement. Section 232, it talks about merger and amalgamation of companies. Section 247(1), it is very important section and we will see further details in next slide. However, this section talks about qualification, experience, process of registration of valuers and penal provisions for valuers. Subsequently, the Companies Bill 2017 was published based on this section. Then last important section is 281(1). So it talks about submission of report by company liquidator. Now let us talk about section 247 and what are the penal provisions given in the section 247(1) in the Companies Act. So if valuer is found guilty of contravening the provisions of this section, the valuer shall be punishable with minimum fine of 25,000 rupees which may extend up to 1 lakh rupees. 1 mark theory question is almost expected from this only one slide. So if the valuer is found guilty, then fine up to 25,000 and may ranges up to 1 lakh rupees. If valuer contravenes with provisions of this section with an intention to defraud the company or its members, shareholders, valuer shall be punishable with an imprisonment of term up to 1 year and minimum fine of 1 lakh, but may go up to 5 lakh rupees. Where the valuer has been convicted, declared guilty of a criminal offence, he shall be liable to refund the remuneration received by him to the company and pay for damages to the company or to any other person for loss arising out of incorrect or misleading statements of particulars made in his valuation report. So last topic of today's session and ongoing playlist is registered valuer rules and valuation rules. So eligibility for registered valuer. A person is eligible to be registered valuer if he or she is a valuer member of an RVO. He or she is recommended by his RVO for his registration as valuer. He or she has passed the valuation exam under rule number 5 within 3 years preceding the date of making an application for registration under rule 6, and he or she also possesses the desired qualification and experience as under. So if he has done post graduation, degree, diploma, then with 3 years of minimum experience. In case of bachelor degree or equivalent, with minimum 5 years of experience is required. A member of a professional institute with 3 years of experience. So other conditions, other requirements for getting registered as a IBBI registered valuer are: he should not be a minor, he is not declared to be of unsound mind, he is not discharged bankrupt or has not applied to be adjudicated as a bankrupt, he is a person resident of India, he has not convicted by any court for any offence punishable with the imprisonment for a term exceeding 6 months. Please note down this time tenor. Period of 5 years should get lapsed from the date of expiry of the sentence. If a person has been convicted of any offence and sentenced to imprisonment for a period of 7 years or more, he shall not be eligible to be registered. Please note on this point. 1 mark theory question may come out of it also. He has been levied penalty under section 27 IJ of Income Tax Act and 5 years have not been lapsed. This is also important point. And he is fit and proper person. So this is the eligibility criteria for registration of a valuer company, valuer firm. The main objective of the entity should be rendering professional or financial services, including valuation services only. The entity should not be undergoing into insolvency resolution or should not be an undischarged bankrupt. All partners or directors should meet criteria in their individual capacity as under, which is applicable for individual valuer empanelment registration is all. So he or she has passed the valuation exam under rule 5 within 3 years preceding the date of making the application for registration under rule number 6, and post graduation he should have minimum 3 years of experience and bachelor degree or member of professional institute degree. Post graduation he should have 5 years of experience. Post membership of professional institute 3 years of experience is required. He should not be a minor. He should not be declared of unsound mind. He should not be discharged bankrupt or has not applied to be adjudicated as bankrupt. He should be a person resident of India. He has not been convicted by any law, any court, for any offence punishable with imprisonment for a term exceeding 6 months. Period of 5 years should get lapsed from the date of expiry of sentence. If a person has been convicted of any offence and sentenced to imprisonment for years of 7 years or more, he shall not be eligible to be registered. He has been levied penalty under section 27 IJ of Income Tax and 5 years have not been lapsed after levy of such penalty, and he is a fit and proper person. So all or three, whichever is lower, partners or directors of the firm or company should be registered valuer. This is also important term, important criteria requirement, and at least one partner or director should be registered for the asset class for which the company or firm is also required to be registered. These are the criteria for registration of a company or firm as a valuer, registered valuer as per IBBI. So that's all for today's session. Thank you for watching. Please subscribe to the channel if you have not done till now, and click on bell icon for future upcoming videos. So in next session we are going to discuss about new chapter, which will be there was a request from one of my viewer to take up this session first. So we'll discuss about professional business ethics and standards. Very easy and small and scoring chapter, and you will not get this material from anywhere in any book. So we'll discuss about model code of conduct under the company's rule 2017, then integrity, fairness, remuneration, cost, occupation, employability, restriction, business ethics, and ethical consideration under terms of engagement. And all these terms we'll also discuss in subsequent session. The terminology we discuss in the current session, in previous session, about succession fee, or a few terms we saw. So we will reiterate those terminologies in next session. Thank you for watching.